Hello and welcome to Manika IAS. In the previous video, we had discussed about the right to equality, Article 14. In this video, we'll discuss about Article 15. Article 15 prohibits any sort of discrimination on the basis of religion, race, caste, sex, or place of birth. Right? So it is an anti-discriminatory article on these grounds, which includes religion, race, caste, sex, or place of birth. Right? These are the 5 areas on which it has prohibited any sort of discrimination. Now, the very first clause of Article 15 says, the state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them. Now, what does this implies? This implies, first and foremost, that this article is enforceable only against state. It is not enforceable against citizens or any other individual but the state. Second, it shall not discriminate against any citizen. That means this article is available only to the citizen and not to the other individuals who are there in the country, but only to the citizen. And then only on the grounds of, only on these 5 grounds. Now, what does the term only implies here? Only implies these 5, either one of them or 2 of them or all of them cannot be the only reason for any sort of discrimination. However, if there is any 6th reason along with them, then that can be considered as a valid reason depending upon its merit. Okay. However, if these are the only reason, then that is prohibited. But apart from these, if there is another reason, then that is accepted. Say for example, if you see in defense forces, there are certain roles which are denied to the women, not on the basis of gender, although this can be one. However, the primary reason is that there are some biological differences and the demand of those is such that it needs men more than women in that particular role. So that was justified because gender is not the only reason of discrimination. However, there are some other reasons as well. And if you see civil services, because there is no such role which depends upon the biological capabilities of any individual, so there is no such discrimination. Either it can be anyone who can be there in army. In army you have very high physical standards, but in civil services you do not have such high physical standards. So because the job is not that demanding, so that is why there is no discrimination if you see in civil services. However, there is a sort of discrimination in certain roles, but because of the needs and the demand of those roles, which can be fulfilled by a particular individual but cannot be fulfilled by certain other individuals. Okay, so this is the very first first clause of Article 15. The second clause says, no citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subjected to any disability, liability, restriction on conditions with regard to access to shops, public restaurants, hotels, places of public entertainment, use of wells, tanks, bathing ghats, roads, and places of public resort, maintained wholly or partially out of state funds or dedicated to the use of the general public. Now, there are 2 things that you need to know. Apart from that, they cannot be. It says that citizen cannot be denied on the basis of these particular areas, that they cannot be denied access to any sort of public restaurant, shops, or tanks and wells. What is important for you to know is why this was inserted, because if you see at a particular point of time, there were people who were denied access to, like in wells or tanks, and during British times also Indians were not allowed to be in certain places, right? So that was the agenda to done away with the sort of discrimination which was prevailing at that time. Second thing to note here is, now this article, the subclause 2 of Article 15 is enforceable not only against state but also against individuals and other civilians, right? Because it doesn't say that state shall not. They should not be discriminated on these purpose, but this is not only enforceable against it but enforceable against citizens, individuals as well. So this is the core difference between the two, and apart from the provision, here it's saying that the state shall not discriminate, and here individuals shall not discriminate along with the state, obviously, right? Now this Article 15 clause 3, it says nothing in the article shall prevent the state from making any special provision for the women and children. Now, on the one hand, Article 1 and 2 said you cannot discriminate on the basis of gender. It said that, right? However, the subclause 3 says that the state can make special provision for women and children, right? Now, this is because, as we discussed in the 14th article, that equal people should be treated equally, and this is to ensure equity in between the vulnerable groups, because these were the more vulnerable groups. So give a sort of protective shell to the vulnerable group, the article was inserted. Now, one thing that you must see, that it says nothing in the article shall prevent the state from making any provision, whereas subclause 1 and 2 of Article 15 were mandatory. This is discretionary. That means it can make, it can opt not to make. But when it comes to Article 1, the Article 15 clause 1, the Parliament or the state do not have any option. They have to abide by. So these are the enabling provisions. These are enabling provisions. Whereas 1 and 2 are your fundamental rights. These are not fundamental rights. These are your discretionary provisions as well. These are mandatory, right? And it is up to the Parliament to make laws or not make laws. So, and to give effect and to make better conditions for women, in the 73rd and 74th Constitutional Amendment Act, 33% reservation was made in favor of women in Parliament, Panchayati Raj and municipalities, and similarly following that, in new 108th Constitutional Amendment Act, the 33% of reservation of seats in Parliament has also been given to the women. So this is justified under Article 15 clause 3. Now when this is about women and children, Article 14 says nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of any socially and educationally backward classes of citizen, or for the scheduled caste and scheduled tribes. Now if you see this article and this article, this is dealing with the special provisions for women and children. However, this is dealing with the special provisions for SC, ST and backward classes, which are socially plus educationally backward. Economically is not the criteria. If these two sort of backwardness is there, then you can make special provisions for the advancement of this section, because again this is the vulnerable section. Same reason. And the area on which the Parliament can make law is wide, because it is not restricting कि किस purpose के लिए. The purpose is not mentioned here, they can make for the advancement. So the area, the scope of these two provisions are extremely wide. Now come to Article 15 clause 5. It says that nothing in this article or in subclause G of clause 1 of article 19 that we'll discuss later shall prevent the state from making any special provisions by the law for advancement of socially, educationally backward classes of citizen or SC/STs, that means OBC, SC and ST, insofar as such special provision relate to admission to education institutions, including private education institutions, whether aided or unaided by the state, other than the minority education institutions. If you see the language of the previous article, which says that you can make provisions for the advancement of the socially and educationally backward OBCs and classes and SC and STs. That was vast interpretation. Now here come to this. It is categorically saying that you can make provisions for the admission to the education institutions, and you can, apart from the education institution, it includes private education institutions also, and that can be aided by the government, that cannot be aided. So the government has all the right to make special provision for the educationally and socially backward OBCs and SCs and STs in favor of them in education institution. They can be government, they can be private, they can be colleges, they can be schools, right? However, they cannot make reservations in minority education institutions. Apart from the minority education institutions, government can make reservations for these classes in the private education institutions or the government education institutions. And to give effect to this, the government made the Central Education Institutions Reservation in Amendment Act 2006, in which 27% reservation was given to OBCs and SC and ST the remaining, right? And then Article 15 Clause 6. It was introduced by the means of 103rd Constitutional Amendment Act, and it is famous because it gave reservation for economically weaker sections. Advancement of economically weaker sections of the citizen other than the class mentioned. That means economical weaker section not of SC, SC and OBC but for the general category, and it gave reservation of 10% above the 50% which was already given to SC, ST and OBCs. This was already given. They have also given additional 10% reservation to economical weaker section, and they have also laid down the criteria. The criteria is 8 lakh per annum if the income of the family is 8 lakh per annum, plus they have some agricultural land or they have some residential flat in a city. So there are certain criteria which are being laid down, but they have this article also provide reservation of EWS in school education institutions to up to 10%. It was added in 103 Constitutional Amendment Act. However, this matter is still sub judice. This matter is sub judice and the court is yet to give decision on this particular matter because earlier the court said that you cannot give reservation to economically weaker section because the constitution mentioned only socially and educationally backward classes. But however, they have amended the constitution by a rightful means. So let's see what the court decides. Second thing is, the Supreme Court has also laid down a limit of 50% at the maximum ceiling for the reservation. And when you add EWS, the total ceiling, the total reservation goes to 60%. So court is yet to give the decision on this matter. We'll see how the matter turn out in the court. Till then, you read this, and in the tomorrow session, we'll be discussing about Article 16. Whereas this particular Article 15 was dealing with the reservation when it comes to education institution, Article 16 deals with the matter in the employment. So that is very important, and it's important for you to read it before in order to understand that article in a better manner. Thank you. Have a nice day. You can ask the question in the comment section below if you have any doubts. Thank you.